In 1986, Earl Jerome McGahey, who is black, was charged with 2 counts of capital murder in the deaths of his ex-wife and her classmate in Selma, Alabama. Mr. McGahey was tried by an all-white jury in a county that was more than 55% African American, after Dallas County District Attorney Ed Green removed every one of the 24 African Americans who qualified for jury service. Remarkably, the prosecution asserted that more than 1/3 of the African Americans called for jury service in Mr. McGahey's case were of low intelligence. The struck jurors included mechanics, ministers, and community leaders, many of whom participated in the Selma civil rights movement. William Minor, a school principal at the Phoenix School in Selma, Alabama, was one of these excluded jurors.
I mean, I could sit on a jury and rule and judge fairly. I'll make an intelligent decision as to a person guilty or innocent of being guilty. It's not fair if you exclude African Americans. No, I don't think that's fair at all.
And I'm feeling good.
Tonight, the demand for change is stretching beyond law enforcement and into the courtroom, where nationwide, black people are convicted at higher rates.
They're prosecuted more, they're arrested more, they're punished more. And very few people who look like them actually sit in judgment of them.
Brendan Woods, the chief public defender in Oakland, California, says it all begins with bias during jury selection.
I have an African-American woman in our office here who's tried cases, over 20 cases, and she can count the number of black jurors she's had on her jury on one hand.
Discrimination is illegal, but peremptory challenges allow the prosecution and defense to dismiss potential jurors without any cause. While either side has the right to object to strikes that appear racially motivated, Woods says prosecutors often defend their strikes using reasons that only appear race neutral.
I had a juror, an African-American woman, who was actually excluded because she was wearing what's called a puffy coat.
A new review of appeals involving issues with peremptory strikes finds prosecutors striking black jurors in 72% of those cases, while striking white jurors in less than 1%. Some of the reasons? Because they had dreadlocks, were slouching, wore a short skirt and blinged out sandals, visited family members who were incarcerated, or had negative experiences with law enforcement.
The Supreme Court today overturned the murder conviction and death sentence of a black man in Georgia. In a 7-1 decision, the court ruled prosecutors had unconstitutionally excluded African Americans from the all-white jury. The sole dissenter was the only black justice, Clarence Thomas. Here's Chief Legal Correspondent Jan Crawford.
The opinion by Chief Justice John Roberts underscores the long-held principle: race cannot be a factor in excluding blacks from juries. But in the 1987 murder trial of a Georgia man, the court said the focus on race by prosecutors did just that, demonstrating a concerted effort to keep black prospective jurors off the jury. The decision paves the way for a new trial for Timothy Foster, who was convicted of the brutal rape and murder of an elderly school teacher and sentenced to death. The justices had signaled at oral arguments they were troubled by the case. Justice Elena Kagan said the prosecutor's conduct was as clear a violation as a court is ever going to see, thanks to the discovery of the prosecutor's notes. The names of the potential African American jurors were highlighted in green, and in this list of possible jurors titled Definite No's, the top 5 people are black. Georgia argued that prosecutors had flagged the black prospective jurors to make sure they were following new Supreme Court guidelines handed down in a landmark 1986 case to prevent racial discrimination in jury selection.
65 potential jurors were selected in this murder case, and today we have 12. And as we mentioned, only one is black. The Superior Court Judge Timothy Walmsley, who will oversee the courtroom, has acknowledged, as Alex just said, that intentional discrimination by attorneys has been seen for those 3 defendants, appearing to have shaped the jury selection now, and it's already created quite a conversation and controversy there at the courthouse.
this court has found that there appears to be intentional discrimination in the panel. That's that prima facie case. And I guess before I get into this, one of the challenges that I think counsel recognized in this case is the racial overtones in the case. Quite a few African-American jurors were excused through preemptory strikes exercised by the defense. But that doesn't mean that the court has the authority to reseat. The court is in a position where it's got to make another finding, which is that the defendants are not genuine when they gave a reason, and that the reason they were claiming is not the real reason those particular jurors were struck. I've worked through each one of these. I've listened to the defense. Again, in the state of Georgia, all the defense needs to do is provide that legitimate, non-discriminatory, clear, reasonably specific, and related reason. And the court is not going to place upon the defendants a finding that they are being disingenuous to the court or otherwise are not being truthful with the court when it comes to their reasons for striking these jurors. So because of that, and because of, again, the limitations I think Batson places upon this court's analysis, I'm denying the motion.
I don't understand you people. I mean, all these picky little points you keep bringing up, they don't mean nothing. You saw this kid just like I did. You're not going to tell me you believe that phony story about losing the knife and that business about being at the movies? Look, you know how these people lie? It's born in them. I mean, what the heck? I don't have to tell you. They don't know what the truth is. And let me tell you, they don't need any real big reason to kill someone either. No, sir. They get drunk. Oh, they're real big drinkers, all of them. You know that. And bang, someone's lying in the gutter. Well, nobody's blaming them for it. That's the way they are, by nature. You know what I mean? Violent. Where are you going? Human life don't mean as much to them as it does to us. Look, they're lushing it up and fighting all the time, and if somebody gets killed, so somebody gets killed, they don't care. Oh, sure, there's some good things about them, too. Look, I'm the first one to say that. I've known a couple who were okay, but that's the exception, you know what I mean? Most of them, it's like they have no feelings. They can do anything. What's going on here? Well, I'm trying to tell you. You're making a big mistake, you people. This kid is a liar. I know it. I know all about them. Listen to me. They're no good. There's not a one of them who's any good. I mean, what's happening in here? I'm speaking my piece and you... Listen to me. We're this kid on trial here. His type. Well, don't you know about them? There's a danger here. These people are dangerous. They're wild. Listen to me. Listen.
I have. Now sit down and don't open your mouth again.
It's always difficult to keep personal prejudice out of a thing like this. Wherever you run into it, prejudice always obscures the truth. I don't really know what the truth is. I don't suppose anybody will ever really know. 9 of us now seem to feel that the defendant is innocent. But we're just gambling on probabilities. We may be wrong. We may be trying to let a guilty man go free. I don't know. Nobody really can. But we have a reasonable doubt. And that's something that's very valuable in our system. No jury can declare a man guilty unless it's sure.
Chapter 11. Open thy doors, O Lebanon, that the fire may devour thy cedars. Howl, fir tree, for the cedar is fallen, because the mighty are spoiled. Howl, O ye oaks of Bashan, for the forest of the vintage is come down. There is a voice of the howling of the shepherds, for their glory is spoiled. A voice of the roaring of young lions, for the pride of Jordan is spoiled. Thus saith the Lord my God, feed the flock of the slaughter, whose possessors slay them, and hold themselves not guilty. And they that sell them say, Blessed be the Lord, for I am rich, and their own shepherds pity them not. He shall do no unrighteousness in judgment. Thou shalt not respect the person of the poor, nor honor the person of the mighty, but in righteousness shalt thou judge thy neighbor. He shall do no unrighteousness in judgment. Thou shalt not respect the person of the poor, nor honor the person of the mighty, but in righteousness shalt thou judge thy neighbor.